How we doing, everybody? We're trying to go through the defense motions on the Sarah Boone case. So let's get to this motion for additional discovery. Now, we talked about this before it happened. We were all kind of trying to figure out what part of her questioning / interrogation was he trying to get out, because we've got tons of body cam, right? We've got them first on the scene. Then the detectives come in at the crime scene. Then the detectives put her in the car at the crime scene. They do read her Miranda rights there, though. Then the detectives bring her back to the station. She arrives at the station voluntarily, and they read her Miranda rights then as well. So it was one of those 4 instances where we felt like he was trying to get that thrown out, and we just weren't positive. Well, we're going to find out right here now which one of those he was specifically aiming at. Oh, and by the way, before I forget, you guys, YouTube's now added affiliate links for content creators. I've got a shopping experience down below. So if you click that shopping link and you purchase something, by clicking that link, I get a commission on it. It helps out all your content creators, and you guys get what you want. And they're always running great sales too. So pay attention to those. They're fairly new. Let's get to it.
I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken.
Yeah, you think?
The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020.
You know what I find funny here is I would have thought that anybody that was working on the case as an attorney or an investigator or anything like that would have gotten kind of bumped up on the list of priorities in asking for these public records that are available, because, Florida's an open state. They're like, it's all out there. But apparently not. I think he might be behind me on the request.
And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation.
Now, keep in mind, everybody, this is Sarah telling him what happened. And we all know, just from listening to her talk multiple times, which have all been recorded, that she likes to bend the truth. She likes to, she likes to chew the truth up and spit it out in her own little diagram and description that really never comes around to what the real truth is. You know how they always say there's always 3 parts to the story: his story, her story, and what really happened? I think in this particular instance, we have the investigator's story, George's story, and whatever Sarah wants it to be in Sarah's world, in Sarah's wonderland.
got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with two
She had full access to the door. They were not blocking her path to the door.
homicide detectives. One was wearing a firearm.
I told y'all they were going to say something about him wearing a gun in the interrogation room. You can say it. Go ahead and say it. I was right.
I was right.
And she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly and she left out the main question at the end.
The main question at the end. I don't remember exactly what it is. You have a right to remain silent. You have a right to an attorney. Anything you say and do will or can be held against you in a court of law. Do you understand all your rights that I've read to you today? With all those rights being read, are you willing to speak with me at this moment in time? I think that's what he's talking about.
So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information.
Y'all know the ladies at the Orange County clerk's office, they hate all of us. And they especially hate Sarah Boone because how many people representing her have contacted them about her documents. And they're like,
Yep, send it already here. Our new attorney wants a copy now. Okay.
they probably have a folder set up. Like they've already probably got it in packets and everything ready to ship out. It's like ordering something from Amazon over there when it comes to Sarah Boone. Seriously.
The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff.
Well, Jamie, you better get to it.
I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this. Any discovery request, whether it is of the state or a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law, relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but
Why
it
don't
should
you?
be weighed
Why aren't you prepared?
with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made
Is that a threat, Jamie?
by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment.
Okay, I'm going to pause it right here because I want to show you guys something. This document that we're viewing right here was dated February the 24th of 2020. It was done on the scene when the crime scene investigators got there. There's specifically some wording in the, I'll read this. Shoot, let me find that part. On February 24th of 2020, Sarah gave verbal and written consent by a signed waiver and affidavit form for the Orange County Sheriff's Office to search her iPhone XS. It even put her model number on there. The digital forensic investigator responded to the scene and began to download the cell phone. While the cell phone was being downloaded, the 2 suitcase videos were found on the cell phone. When that occurred, I'm trying to find the notes. When that occurred, they issued an additional warrant. So they stopped looking at the cell phone because they knew they had a crime scene on their hands. So this form right here is what protected them from picking up that phone and looking at it and everything right then and there. I hate Microsoft Edge. I really do. So anyway, as you'll see, it says there's her initials right there, SKB. It's a black iPhone. There's her address. Black iPhone with pink, I think it might be a pink cover. Is that what it says? Pink case. Nothing else on here was noted. Nothing about the house or anything, but considering it was a crime scene, here's her signature down here at the bottom. Again, February 24th, 2020. They had every right to do that at that point because it was a crime scene. Someone had died on the scene. They had the right to go in there and investigate. Once they saw the videos, that's what alerted them. They already knew it was suspicious, obviously. They were like, something's not right. But once they saw the body cam, that's when they issued a formal warrant to dissect her phone, so to speak. So let's get to this part.
Afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant. I'm not feeling well. I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items. And she saw the male detective and said, is this where I go to get the phone? He said, no. We got it back here in this room. Come back here in this room and we'll get it.
And just so you guys know, what he is about to describe right here is pretty much done all the time. And they're allowed to do it. Some people find it shady. They walk a fine line sometimes. But I don't believe them coaxing her into that room, because they probably did kind of coax her into it, was an issue. Just from everything I've read up on this, that's what I believe.
When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again.
Okay, first of all, nothing that Chelsea does has that much expression in it. She's like, I've got your Miranda warnings. I need to read you. So we've looked at the ME report. She so doesn't want to be wherever she is. So him showing some excitement about how she's saying it, it's completely off. It's completely off. It's irrelevant, but it's off.
And
Again,
she had read them. There was a statement that Sarah Boone gave.
Oh, wait, I want to see that again.
We got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And
again,
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. She asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol, because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim.
I could see James Owens. He's going for Making a Murderer 2.0, the Sarah Boone story, and he wants to be the star.
The
He'd be the producer of it too.
constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video.
Yes, we do.
There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they.
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling.
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
Yes,
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's
Now,
correct.
you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
That's a simple constitutional issue, right?
yes.
If there's a case law that buttresses that position and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so. Along
It doesn't
with
answer
her
my
other 2
question.
I love Judge Cranick.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted to.
I'm gonna bring it up, but I'll show you my proof later. I'm just gonna bring it up right now, and we'll. No, you want that? Okay. Well, I'm just gonna bring it up still, though. We'll talk about it later when I'm ready. Oh, you want me to work for it? Okay. Well, then I'll come back next time, and I'll bring the proof with me. What the?
Policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy.
She didn't say it like
Those
that.
type statements are improper.
First of all, it wasn't that. All she had to do was, we have his autopsy. This I can just hear it now. Chelsea. Yeah, so we got his autopsy. Oh, you came to get your phone? Okay, hang on just a minute. Oh, we got his autopsy report back. And as Chelsea gets up from her desk to go make herself a cup of coffee, Sarah follows behind to the coffee machine and says, "You did? Are you going to read it to me? Or are you going to tell me what's on it?" Chelsea turns to her and says, well, I can if you want me to. And then before you know it, bam, chicka, bow, bow. They're in the interrogation room. Okay, I'll stop now. I really got to get a life.
They're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak.
Is that why she was coughing? Because she was chewing at the bit and she was choking? That's what it was? Oh, okay.
To them. and to not exercise a fundamental right, not to speak to them, a lawyer being present. So she made those two statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Phew.
The Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief, or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately. The state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
You know what's crazy, you guys? How many times does this specific topic come up? And everybody always says, why didn't you ask for an attorney? Why did you talk to them? And I think we mentioned it, I don't know, I think Sam and I were talking one night and we mentioned it about, doesn't matter what anybody thinks. When you decide that you need an attorney, when you get that little, not that you're ever going to be, let's hope you're never going to be sitting in an interrogation room, but for those of you out there that plan on it, listen up. So it's like, you're going to get that little sense, and it's called intuition. We women, we call it women's instinct. It's like, you just know something doesn't feel right. And, oh, okay, I probably should get an attorney. Oh, but I don't want to look guilty if I ask for an attorney. Who cares? Who cares if you look guilty? Because at the end of the day, if you're like me and you've watched all these Datelines and 48 Hours and all these TV shows, you will see that whether you ask for one or not, well, when you ask for one, they say that you look guilty anyway. When you don't ask for one, they'll say you sung like a canary, or they'll sit there and laugh in the interrogation and say they just offered it all up. So, I mean, either way, they're going to talk about you. So who cares? At that point in time, do you really care about that few moments of what people think about you versus sitting the rest of your life in a jail cell, sharing snack cakes with Tina, your bunkmate, who, by the way, smells really bad. Really bad. Just saying.
In reviewing the authority provided by the state, which the defense has considered is taken is what it is. I think State versus Wright is the guiding light for the court here. 803 Southern 2nd 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Oh my God, this is not fair. This is not fair. Oh, it's okay, James. Don't worry. We're only on motion number 2. You still got 3 more chances not to get denied, even though you've been denied on the first 2. But you know what? He knew he was going to get denied. You guys know he knew he was going to get denied. That's what they do, right? They throw it out there in hopes that it's like going fishing. You know, yesterday, or my last video, I compared it to baseball. This video, I'm going to compare it to fishing. You throw your pole out there and you hope something bites. That's what a lot of these defense attorneys do. State's got to come in and they got to prove it. You just try to throw up hurdles that they have to jump over to keep them from proving it. And if you're like James Owen and you like attention and you like the spotlight, you're going to make a really big show out of all of it. So you guys, grab your popcorn. And on the 26th, which is coming up in just 5 days from me recording this, we will be live watching the next hearing. And I can guarantee you, we're going to be on this live for quite some time. I guarantee you we're talking, if this was a 2-hour hearing that we just had, the 26th, which is the trial conference hearing, it's going to last half a day. It's at least. I just anticipate it. So take the day off if you need to. Leave work early, whatever you need to do, people, but you need to be here. Okay? Oh, and by the way, if you are looking for the full play of this actual hearing from the 19th, you can always go back to my channel and my live streams because we did stream this live when it was happening. These pieces that I'm throwing out there to you guys, I'm just trimmed some stuff down just so we can get to the heart of the matter. In the words of Glenn Fry, heart of the matter. Just trying to get down to the heart of the matter. Wasn't that Glenn Fry? Was that Glenn Fry? Forgiveness. Well, was that his name? Glenn? No, it wasn't Glenn. It was the other eagle, wasn't it? Oh, shoot. I don't remember. Anyway. If you know what song I'm talking about, then cool. All right. Got to go look at another motion, and I'll be back soon.